Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I have several different videos on, what it takes to become a certified specialist in immigration and nationality law, and you can, go on the website, the bar website, and see. You can see a whole bunch of lists that what is involved and what it takes to become a certified specialist in immigration and nationality law, which I've been certified in the state of California. But I thought, just as a explanation, rather than tell you about all the years' experience and the different categories that you have to learn and all the other stuff. I pulled a question, actually I have here a paper, and these are, first two questions of past certification exams. So let me read you a typical question on a certification exam, and then I'll just give you my thoughts on what I would do and how I might answer it. And this is essentially at least one part of the certification exam, where several questions are asked, and they have to test your knowledge on whether or not you can see the issues and answer what needs to be. So let's get to it. Okay, so here's the question. Edward, a native and citizen of Malaysia, has consulted with you. He is presently lawfully in the United States under valid H-1B status. Edward first entered the United States in August 1993 with an F-1 visa issued by the American Embassy in Malaysia. He graduated from UCLA in June 1997 with a bachelor's degree in aerospace engineering. He was granted a one-year period of practical training upon graduation. His H-1B visa petition was approved in June 1998 to work as a procurement engineer for SA Enterprises, Inc., a United States company engaged in exporting aircraft and related items. Shortly after his I-129 was approved, Edward traveled to a U.S. consulate in Mexico and was issued an H-1B visa valid for 3 years. He was granted an extension of his H-1B status in May 2001, valid until June 2004. Again, Edward went to a U.S. consulate in Mexico to apply for another H-1B visa, which was issued for another 3 years. SA Enterprises, Inc. filed an application for alien labor certification on behalf of Edward with the California Development Department on April 30th, 2001. It is still pending. SA Enterprises, Inc. is owned by Edward's uncle, who closed the company last month and returned to Malaysia due to an FBI investigation of his activities. Edward has been offered employment as a design engineer by another company which manufactures airline parts. The company is willing to petition for his new H-1B and his permanent residence. Okay, so that's the question. All right, there's several subparts to the that's the question. Now there's several subparts to what they want to know. Okay, so A, when can Edward begin working for his new employer? Discuss. Okay, so in this particular case, we have to look at the issues as to whether he can work for his new employer. First of all, if you look at the H-1B issues here, one will know that you get 6 years maximum H-1B, and then that's it. Then you have to leave for a certain period of time, and then you can come back. However, there's an exception, and the exception is if there is a pending bona fide labor certification or I-140 petition, then the H-1B can be extended on a yearly basis until the perm or labor certification or I-140 is approved. Now, a couple issues here. It only talks about the fact that Edward had received 2 3-year H-1Bs. He never applied for the H-1B extension, and so we can assume that since he did not apply for an H-1B extension under the yearly basis, when one has a pending labor certification, that would have to be done by the new employer. The problem with that is that because his company that petitioned him for the labor certification, which was owned by his uncle, is shut down because of various reasons, that means his labor certification's over, is no longer pending. And because it's not pending, that means that he would have to, he couldn't apply for the 1-year H-1B extension. That would be impossible. Okay? So then we go to the other line here and we go, well, with the 6-year H-1B, it is possible in which to basically get or recover a certain portion of that. If, for example, you're out of the country, you're on vacation, you weren't working, you didn't come in when the visa started, whatever. So I would have to analyze all of the time that Edward was here on H-1B and see if he has, in fact, time left on that 6 years, because he might. So then what happens is he would be able to file an H-1B portability case with the new employer, assuming he had left any of the 6 years, and start working right away. Then the question also becomes, was he out of status? Okay, because if he was out of status, you can't change status when you're out of status, but it looks like he probably still had at least the H-1B valid for a certain period of time when the company closed down. So in that particular regard, while he would be violating his status by not working under H-1B, he wouldn't be unlawfully present, and he might be able to successfully do another portability H-1B with the new employer. Now, the other issue is that because he filed the company filed the original labor cert on April 30th, 2001, that means he's under 245I, okay? And because he's under 245I, theoretically, he could be out of status and didn't just pay a penalty when the time is right and adjust status. So the question with the new employer is whether they'd be willing to petition him for the perm, for the green card, knowing they might not be able to get him for the H-1B, but because he's under 245I, while he would not be able to legally work at this particular company, should the company decide that they want to essentially look the other way, or that they will take their chances and just petition him immediately for the perm, that's one option that they would have to look at there. We then have to look at the fact that Edward, or his uncle who owned the company, closed the company down and was went back to Malaysia, whether the initial offer of the perm was legitimate in the first place. If it wasn't legitimate, then he's not under 245I, and the whole section of what I just told you wouldn't work, because it needs to be a bona fide job offer in order to be under 245I. So that's an issue as far as that goes. We then also have the issue of the duties of the H-1B. So for example, he graduated in aerospace engineering, yet he got an H-1B for procurement engineering. So then the question is are those related? Does procurement engineering require aerospace engineering? Does it require the particular duties that are under that particular education? Is it a specialized knowledge position that uses what his degree was? And then let's see, I recall reading here when he got his the perm, which was filed, it was yet filed for another type of engineer, a third different type. So the whole question is whether he was qualified in the first place to accept the position, because it did say that the visa number was not current yet, and therefore he wouldn't have been able to file the I-140. Okay, so all of that is a discussion just on the first part of the question, and they have 3 other sections here, but I don't want to bore you. Okay, they have 3 other sections just on this one question, but you can see that what the certified specialist does is we're able to take the facts, we're we pull and tear them apart. We look at them in whole, as the whole under the ambit of immigration law, see how one area affects another area. So, that's why, honestly, when some people give me a call and say, well, I've done some research on the internet and found this and that, it's a little bit humorous, because there is so much analysis and education and experience that goes into when someone sits in front of me and tells me their case. All this experience goes into how I can help them and what the best way to do that is. And being a certified specialist, I am able to analyze it in a manner that will give them the best possibility of success, but it will also see a lot of issues that a lot of other lawyers who are not experienced enough will not see, and that is going to truly affect the client coming down the line. Okay, so if you like the video, click like, click subscribe, give my office a call, and then we'll go from there. More on the coming videos.